Good afternoon, everyone. That was an overwhelming introduction, huh? I keep it simple. I like working with poor people. I've done it following my parents, who did quite a bit in ministry when I was younger. I have a large extended family, and most folks in my family have a commitment to do some kind of service, whether it's been military service, working in church communities, working in legal field communities, or working in medical fields. And so it's something that's kind of been ingrained in me, as I'm sure that's the same as with many of you who are here. Otherwise, you would not be spending 2 days coming to see how you can make our system better. What I want to talk to you about today is a little bit of what the National Association of Criminal Defense Lawyers has done over the last couple of years. If you are able to go to the website, it's nacdl.org. On that first page, on the left-hand side, is a link for the Indigent Defense Committee. And if you hit that link on that first screen page for the IDC committee, you'll see the misdemeanor project entitled Massive Waste Minor, I forgot the title. Massive Waste Minor Crimes. You'll see it on that first page, and it will give you the entire 64-page report. Now, I actually timed a couple of people. I asked them to check this out for me. If you read it from cover to cover, including the introductory, the table of contents, all the endnotes, it takes you about an hour and a half. So unlike most reports that you get, this is one that you can finish. And actually get a lot of substance out of it, even while you're taking notes. An hour and a half is not a long time. So I encourage all of you to check out the website, as well as to go and actually pick up and read through the project report. The background of the report, that is how some of the data got in there, was done by a lot of research. It was done by people actually going into courtrooms and watching what happens in cases there. It was done through a couple of conferences that NACDL hosted in 2008. There was a webinar, which, if some of you are not familiar with that fairly new term, it's a seminar that's held over the internet. And there were several surveys put out to judges, prosecutors on different levels, defense attorneys on different levels, and then, of course, indigent defense reform activists from all over the country. So there's a great deal of work that went into this project. And one of the things that you may not be familiar with or may not have known before the project came out was that in 2006, the National Center for State Courts collected a misdemeanor caseload numbers for 12 states. The median misdemeanor rate from those 12 states were 3,544 per 100,000. If that rate represented all 50 states back in 2006, there would have been a total of 10.5 million misdemeanor prosecutions. Essentially, that means 3.5% of the American population in 2006 would have had misdemeanor charges against them. That number does not include the non-citizen prosecutions, and it does not include persons who may have gotten more than one charge, that is, multiple charges or multiple cases in a particular year. So that's an astounding number, particularly because most people have a tendency to think of only felony cases when they think about criminal defense and the criminal justice system. But one of the things that we've learned is that more people will come in contact with our criminal justice system through misdemeanors than any other means. And so why, the number one question for this project is, why bother to do it? Why do the misdemeanor project? The reasons are pretty simple, pretty basic, very common sense. The first is, there has been no other national study before this one on what what the quality of misdemeanor defense has been across our country. While other people may have taken surveys, they may have collected some data, they tend to have been in certain counties, certain cities, certain regional parts, as opposed to looking at our national framework. Another reason is that a majority of the state criminal cases, our local cases, are misdemeanor cases. Many of the people who come in contact with our criminal justice system, as I said, come in through the misdemeanor system. And while most people look at misdemeanor offenses as being relatively harmless, there are quite a few collateral consequences and that can impact not just how more complicated our criminal justice systems become, but the repercussions that happen out in the community as a result of how those misdemeanor prosecutions are resolved. And that often overlooked reason, of course, is our U.S. Constitution. Many of you are familiar with the Gideon case that guaranteed that every defendant who is charged with a felony is entitled to a court-appointed attorney if they cannot afford to hire one. Well, Gideon didn't cover misdemeanor cases. And so in 1972, the U.S. Supreme Court heard the Arsinger case, and the site for that is in the Misdemeanor Project, but if you want to write it down, it's 407 U.S. 25, 1972. That extended the entitlement to court-appointed attorneys to persons who were accused of misdemeanor offenses. And then there's another case, the Sheraton case, which extended the cases a little bit further to include persons who are dealing with probation revocation issues in misdemeanor cases. As the Misdemeanor Project went on, what NACDL found was what our former Indigent Defense Counsel, Maureen Dominio, calls rawhide justice. A lot of problems were cross-country, not just within any particular region, where there were no defense attorneys who represented people who were accused of misdemeanors. Not only were there no attorneys appointed, there were no defense attorneys in the courtrooms. So in other words, even if you did not have a specific attorney assigned to you, there was not a public defender sitting on the side somewhere that you can go and consult with as you were dealing with these charges. There were uncounseled pleas. That is, people were pleading and not really understanding the implications of what would happen or could happen as a result of the pleas that they were taking. There were excessive caseloads by some of the attorneys who were being appointed to the cases. There were pleas at arraignment, very first appearance. A person walks in, as you saw the notice on the courtroom door in Andrea's slideshow, before they walk into the door, they have scheduled pleas, and their very first appearance, they're taking a plea. No one's talked to them about what the facts are. No one's talked to them about the implications. Wow. And I gotta talk faster. At their very first appearance, they're already having to make a commitment to plea. Some of the other things that we found in the project was that the misdemeanors are chronically underfunded and understaffed. What's missing are attorneys, supervisors for those attorneys, investigative services, as John D. pointed out to us, all kinds of experts and interpreters. The absence of counsel is a particular concern, and the reason is that there are, among the several listings that you see here on the slideshow, the collateral consequences that I spoke of earlier. We have a tendency to not think of what those can be, but having represented several people who have been charged with misdemeanors, there are things that are on the books that you can't just go and look at the code and find out. For instance, in DC, if you are convicted of a misdemeanor drug offense, you can look all through the annotated code and through the court rules, and you will not find something that's very important if you drive a car. If you are convicted, either after a trial or by plea, the mayor's office can put in a recommendation to have your driver's license suspended. And that's something that you can't appeal to a judge. It's something that you can't appeal to a court administrator because it's handled completely outside of the court system and by the mayor's office. Some of the collateral consequences that this project found across country, beyond the consequences of jail time, include people losing their jobs, families being separated when there are no responsible parents or next of kin who can take care of children who've been left behind. People have lost their housing. They've lost public assistance to other benefits. They've been denied professional licenses. Unfortunately, some of our college students find themselves getting in trouble with misdemeanor cases, and some of them lose funding to be able to stay in college. And so misdemeanor cases are not simply minor offenses. They have life-changing collateral consequences. The recommendations, as you can see, have been first to have the right to counsel observed in accordance with the R. Singer Hamilton and the Alabama versus Shelton cases. The defense counsel should be available to represent the accused person at their very first appearance. Waivers of counsel should be handled carefully with judges ensuring that the defendants fully understand his or her right to counsel as well as the dangers of waiving counsel. And appointment of counsel should be automatic for any defendant who appears without counsel until it is demonstrated through a fair and impartial eligibility screening process that defendant has the financial means to hire an attorney to represent him in his or her matter. Now, one of the ways I know that we've handled that in DC is that there's always a stand-in counsel. In DC, our stand-in counsels can be either a public defender in some of the specialty courts, or it can be a person who's on the court-appointed panel list. And basically, that's someone who is assigned on a week-to-week basis and rotating weeks, different persons, to be in the courtroom for all first appearances. So, and that first appearance, if the person qualifies for an attorney, they will be assigned an attorney. But between the first time they stand in front of a judge and the time that they actually get an attorney appointed or they're able to hire an attorney, there's someone there that they can talk to about their cases. If they're being held, someone to call family, someone to make sure the jail has their medications that they need, someone who can call if they have a job and say, you know, this person needs to be out for a day, but he'll be back soon, he'll be able to contact you soon. There's an attorney there to assist the person the very first day that they're there. What could possibly be worse than an absence of an attorney? Well, one of the things that the Misdemeanor Project looked at included how or who the defendants meet the first time they go into a courtroom. Obviously, they meet the judge. What kind of shocked us was that a lot of times they are first meeting prosecutors before they hear anything about having the right to an attorney, having the right to not incriminate themselves before a judge based on answering questions that a judge may pose to them, that they are talking to prosecutors. Now, the American Bar Association has model rules that are basically ethical rules for the attorneys, and it covers every attorney, whether they are a prosecutor or a defense attorney. Couple of them that are important in this context, go back one, is the 4.3 model rule, which says it prohibits a lawyer, whether it's in a civil case or criminal case, whether it's a defense attorney or a prosecutor, from giving advice to an unrepresented person whose interests may be adverse. So it puts a prosecutor in an ethical quandary to talk to a person who is being prosecuted by their office on what that person should do about their case. Another important one is 3.8, which specifically forbids a prosecutor from seeking a waiver of pretrial rights from unrepresented persons. Now, there is a way that a person can have a waiver, but it has to be informed. They have to be told the consequences of that waiver. It has to be a voluntary, knowing, and intelligent decision by that person. That person has to be able to read and understand the form that they're being asked to sign. Without an attorney there, the prosecutor or the judge may be in the position to act as a pseudo-attorney, which doesn't really protect the rights of the defendant and can slow down the calendar, particularly if you have, can you imagine in the last cartoon in Andrea's slideshow, a judge having time to go through that scenario with, say, 100 misdemeanor defendants every day? It saves time on the calendar to have attorneys who are there, who are available to talk to the defendants before they go in. I'm going to hit hyperspeed. If you're lucky enough to get an attorney, then there are still some issues. The National Advisory Commission for Criminal Justice Standards and Goals set caseload limits for full-time public defenders, and this is noted in the misdemeanor report. They were 150 for felonies, 400 for misdemeanors, 200 for juveniles, 200 for mental health cases, or 25 appeals. In other words, this is not one attorney who's able to take on all of these cases. And that was 20 years ago. These standards assume that the attorneys have the support that they need to do their job and to do it well, which includes having secretarial assistance, having investigatory services available, having a paralegal, having access to online legal research. Without those minimum services available to help that attorney, an attorney's caseload really puts a client in jeopardy. There was an ethic opinion filed by the ABA, it's ethic opinion 06441, that says if a workload prevents a lawyer from providing competent and diligent representation to existing clients, she or he must not accept new clients. And yet we know that there are folks who have caseloads that are going well beyond the standards that were set over 20 years ago. So the recommendations are that funding for misdemeanor defense should permit the maintenance of appropriate caseloads. All persons representing indigent defendants should be subject to caseload limits that take into the account the unique nature of the jurisdiction, its misdemeanor practice, and under no circumstances exceed the national standards. When caseloads become burdensome, defenders, pursuant to their ethical obligations, should seek to discontinue assignments and or withdraw from cases until the caseloads become manageable. One of the nationwide problems, as we've mentioned before, is people who particularly are showing up at their very first court appearance and are involved in plea negotiations or signing away plea forms, signing away waivers of the right, and going right to a prosecutor to talk about pleas. What the recommendations that this report made included a presumption that any effort to plead guilty at a first court appearance is not knowing and not voluntary. This simply, the defendants are making uninformed decisions. Prosecutors should not utilize time limits on plea bargains to coerce early pleas, particularly when the time limit does not permit defense counsel to fully assess the appropriateness of the plea. What that typically deals with is where you go in and you have an attorney with you, and the prosecutor and your attorney are having a discussion. The prosecutor says, I'll give your client this plea, but he has an hour to decide. An hour is just enough time for your attorney to talk to the client about, or to talk to you about what happened in the case from your view. Not even suggesting whether or not they've had a chance to look through the police reports, to talk to any witnesses, to get an investigator and go through this crime scene themselves, just talking to you. But in that time, in some jurisdictions, there are prosecutors who are giving time-limited pleas. And so that puts the attorney at a disposition to talk with their client because they have to tell them what the plea offers are, but they have no basis to give any advice on what that client should do. Even if they have the experience, they are familiar with the charges, they're familiar with the judge, they're familiar with the prosecutor, they still need time to talk to that client and learn about that client and help that client decide what's going to be best for that client in that particular phase of that client's life. The recommendations, again, are that when setting caseload standards for jurisdiction, particular attention should be paid to the collateral consequences of convictions in that jurisdiction, and the time needed by the defender, the attorney, to research, to understand, and to advise the clients with respect to collateral consequences. The youngest and most experienced attorneys will represent people in misdemeanor courtrooms, typically across the country. In Miami-Dade, Florida, they have what has been called the farm system. That is where new attorneys come in and they start out being trained in the misdemeanor section, and then they graduate to other sections, as John D. talked about earlier today. What we're finding is that they get overwhelmed because they have the most excessive caseloads handling misdemeanors. They typically have very little criminal defense background before they come in, and then they get a bit of training in office. There may not be supervisors that go with them to the courtroom to make sure that they are doing what they've been trained to do, that they become familiar with the judge's practices, that they become familiar with how the court administrators handle the calendars, what's expected the first time the attorney walks up with the client. Let alone have the experience to actually sit down and talk with the client the first time that they meet them, and know what they need to know from their client, what they need to know about the charges, and how to carry on a client interview. The recommendations are that public defenders and assigned counsel in misdemeanor cases have regular training, not just initial training, on issues directly related to their practice, including trial skills, substantive and procedural law, and collateral consequences. Public defenders and assigned counsel in misdemeanor courts should be actively supervised by an experienced trial attorney. An experienced attorney should rotate back through misdemeanor practice. That is, if you've been practicing for a while and you've been doing a lot of felony cases, you need to stay in contact with misdemeanor practice before you start supervising persons who are going to be appearing before misdemeanor judges. What happens is that we found that judges are often placed in a position to act as pseudo-defense attorneys from the bench, which doesn't help the calendar, slows the calendar down, certainly does not help the defendant. One of the things that I noticed in Andrea Marsh's last cartoon is that was a defendant who wasn't shaking, wasn't wetting her pants, wasn't scared to death to talk to the judge. Most of my clients will talk to me forever, but they don't want to say a word in front of the judge, because that's the person who can determine whether or not they're going to get out on bail, what they have to do that may cause them to have to lose their job because of the time that they have to do drug testing, going to classes. They don't want to talk to the judge. That's why they talk to me. And my job is to talk to the judge for them. And so a lot of the people who come in, you really have to assume they have no idea how the criminal justice system works, what roles the judge plays, a prosecutor plays, a probation officer plays, pretrial services plays, and even the defense attorneys plays. They are literally coming in like kids who have to be handheld by their attorneys. And so our recommendation is that defender programs should have an active, all judges handling misdemeanor cases should receive extensive training on the importance of criminal charges, the collateral impact of pleading for the defendant, as well as be respectful of all defendants regardless of their ability to pay for counsel, as well as be disciplined for failing to enforce any of the constitutional rights of defendants. That's the lawyer who is experiencing lawyer burnout, because not only are the judges affected, the calendars are affected, defenders are affected, but good attorneys who are very well committed to practicing and doing criminal indigent defense get burned out, particularly because of excessive caseloads, but also because they are filling in the blanks a lot of times, hearing things that judges don't want to hear that clients say, because they don't want to say them in front of the judges. Our recommendation is that defender programs, whether it's public defenders or private programs, have an active program for combating attorney burnout. And finally, how many of you have ever seen, either in a movie or in person, in New York, a person who is sleeping in a cardboard box, okay, or a person who falls asleep on the subway? Those persons who can't afford to sleep anywhere else are subject to 10 days in jail and a fine of at least $50 to $100 because of some of the laws that are still on the book and are still enforced in New York. Anyone ever try to feed someone who was down on their luck, who you thought was homeless? Okay. If you were in Orlando, Florida, you'd be subject to jail time because it's against the law to feed homeless people in Orlando, Florida. These are just some of the examples of overcriminalization that were found by our observers and the research completed in the Misdemeanor Project. Our recommendation is that offenses which do not involve a significant risk to public safety should be decriminalized. It saves money, it saves time, it saves resources for things that really do have a significant impact on public safety. Finally, lack of diversion. For those of you who may not be familiar with it, diversion programs are typically programs where people can do community service in exchange for having their cases dismissed, or do some other kind of community benefit where the offenses have occurred. At the end of the project, where do we go from here? Some of the things are, I think it's one more. Some of the things are forward. There we go. Public education, which you're doing here. Coalition building, which you're doing here. Impacting litigation and statutory reform. I hope you all have enjoyed the slideshow. I can assure you there's so much more information in the Misdemeanor Project report that I could not cover in these 20 minutes, but I hope that you get a chance to look it over, take your notes, and see how it can help you do your job as well as inform others that are in your counties. Thank you all very much.